Good afternoon or good morning, wherever you are. Hello, my name is Dave Bowden, the news editor here at Ballotpedia. The Supreme Court issued the last opinion of its most recent term just under 4 weeks ago, and has been the case for the last couple of years. There were a flurry of rulings at the very end. I counted 23 opinions issued in the last 2 weeks, which is about a third of all the decisions that they issued in the entire term. Anyway, there was a lot going on and a lot of cases to analyze. This term, there were several prominent cases that affected key policy principles of the administrative state, such as our deference, the Non Delegation Doctrine, and judicial review. And if you're unsure about what all that means right now, don't worry, this webinar will help you understand these very interesting concepts. Helping me here today are two staff writers with Ballotpedia, Joel Williams and Caitlin Stiersky. We'll be talking to Caitlin in just a few minutes, but Joel, thank you very much for joining me.
Thanks for having me, Dave.
All right, before we talk about these administrative state-related cases, let's get an overview of the full term. So, Joel, can you catch us up on what's been happening with the Supreme Court over the last 12 months?
Sure. The Supreme Court began hearing cases for the 2018 term on October 1st, and it had its final hearing on April 24th. It released opinions through the end of June. In total, the court heard 69 cases and issued 74 opinions for the term. And the 2018 term also marked the first term on the court for Justice Brett Kavanaugh, who was confirmed on October 6th. It heard 14 cases originating in the Ninth Circuit, which was twice as many from any other circuit. And the next highest was the 6th and 11th circuits, where they had 7 cases each. The court overturned 48 of the 74 cases this term, which was a rate of 64.9%. And for some context, since 2007, the Supreme Court has overturned 69.8% of all cases it's heard. So this year's rate was below average.
That's really interesting about where the cases came from. How about the nature of the court's opinions?
Sure. So this term, SCOTUS issued 22-9-0 opinions, which is a unanimous opinion, and it issued 19-5-4 opinions, which is the closest the court can be split. There are also 2 8-1 decisions issued by the court this term, and in those cases, Justices Thomas and Gorsuch penned the dissents. And then there are a couple of odd number splits. There were 2 5-3 opinions issued for cases that were heard from before Kavanaugh joined the court, and then a 6-2 decision that got issued. And in that case, Kavanaugh recused himself because he had heard the case already on a lower court.
That's some very interesting facts. All right, so what are some of the other noteworthy opinions that the court issued this term, besides the ones that Caitlin will be talking about in a little bit?
Yeah, there are a couple. So the court heard 3 different redistricting cases this term. 2 of them dealt with partisan gerrymandering of congressional districts, and those are in North Carolina and Maryland. And in those 2 cases, the court issued a joint ruling on June 27th, where they said that partisan gerrymandering presented political questions that fell beyond the jurisdiction of the federal judiciary. In those cases, Chief Justice Roberts authored the majority opinion and Justice Kagan penned the dissent. And if you want to read more about those 2 cases, I'd recommend you check out our July edition of the Ballot Bulletin newsletter, where we went into those in greater detail.
Yeah, those were very very interesting cases around Ballotpedia as well, because they kind of covered both the election side and the court side. Those were very interesting. Now, you said there were 3 cases on districting. Those were the congressional district ones. What was the one dealing with state legislative districts?
Yeah, so that came from the Virginia House of Delegates. And in that case, a 5-4 majority consisting of Justices Thomas, Ginsburg, Sotomayor, Kagan, and Gorsuch ruled that Republicans in Virginia lacked the standing to appeal a lower court order that implemented a new district map for the 2019 elections. And this will have a big impact on those elections, because the old map was one where Hillary Clinton won 51 districts and Trump won 49 in 2016, and now that'll be 56 Hillary Clinton districts in 2016 and 44 Trump districts.
And we'll obviously see, or potentially see, the impact of that with those elections coming up in the fall. Now, I know the court has already agreed to hear 44 cases in the next term. They generally hear from about 70 to 90 each year. Joel, are there any cases that they've agreed to hear at this point that stand out?
Yeah, there's a couple. So in October, the court is going to hear 3 cases related to Title VII employment discrimination that are related to sexual orientation and transgender individuals. And so the court consolidated the 2 sexual orientation cases into one hearing, and then it'll hear the transgender discrimination case separately. In the sexual orientation cases, the 2nd and the 11th circuits ruled differently on the matter, so the Supreme Court's going to settle that dispute. And then in November, the court is going to hear arguments in 3 cases, asking the court whether the Department of Homeland Security's decision to end the Deferred Action for Childhood Arrivals program could be reviewed by a court, and if it can be, whether the action is lawful. The decision to end DACA has been on hold since January 2018, when a federal judge in California issued an order that blocked the DHS from ending it.
All right, so those are definitely some very prominent cases we'll be tracking and following here. Thank you very much, Joel. Now joining me to discuss the impact of the Supreme Court term on the administrative state is staff writer Caitlin Stiersky. Thanks for joining us, Caitlin.
Great to be here, Dave.
All right, we had 6 cases this past term that had implications for the administrative state. Let's dive right in by taking a look at the first one, which was Weyerhaeuser Company v. United States Fish and Wildlife Service. Can you tell us why this case sparked interest among both journalists and administrative law scholars?
Great question, Dave. So Weyerhaeuser was an interesting case because many analysts thought it provided an opportunity for the Supreme Court to re-examine Chevron deference. Deference, for those who are unfamiliar with the term, is one way federal courts handle unclear statutes. When courts defer to federal agencies, they uphold the agency interpretation of an ambiguous statute, even if the court might have had a different interpretation. So the Chevron deference doctrine in particular requires courts to defer to agency interpretations of ambiguous statutes administered by the agency, as long as those interpretations are reasonable.
That's interesting. So then what was the statute at issue in Weyerhaeuser?
Well, in Weyerhaeuser, the U.S. Fish and Wildlife Service interpreted provisions of the Endangered Species Act to designate an area of critical habitat for the dusky gopher frog, and the landowners objected. The Fifth Circuit Court of Appeals applied Chevron deference to accept the agency's interpretation of what can be considered a critical habitat.
Okay, so that's how the appeals court ruled. What did the Supreme Court have to say?
Well, what's interesting here is that the Supreme Court decision didn't address Chevron deference at all. So Fish and Wildlife had argued that the critical habitat designation wasn't reviewable by the courts in the first place because the law left the designation up to the agency's judgment or discretion. But the Supreme Court disagreed and found that the agency's process for designating critical habitats, though discretionary, also required consideration of economic effects, and those calculations provided meaningful standards for the court to evaluate through judicial review to determine whether the agency's action was actually an abuse of discretion.
So analysts thought that the Supreme Court would address deference in Weyerhaeuser, but the ruling ultimately had to do with judicial review?
Exactly. So the court held that Fish and Wildlife's critical habitat designations are subject to judicial review, and they sent the case back to the Fifth Circuit to determine whether the agency's decision was arbitrary, capricious, or an abuse of discretion. Some journalists and scholars argued that the decision strengthens judicial oversight of discretionary agency actions, but others claimed that the ruling obstructs agencies' ability to exercise discretion.
All right, so that's still, I guess, a principle to be decided. What about our next case, Kaiser v. Wilkie? Now, journalists and scholars thought that this case would concern deference as well. Were they correct?
Yes, in Kaiser, the Supreme Court upheld our deference while at the same time limiting its application. So while analysts had speculated that the court could overturn our deference altogether, the justices ultimately upheld the deference doctrine, but they narrowed scope.
Okay, that's interesting. Can you tell us a little bit more about our deference and then how the court's decision changed it?
Sure. So our deference requires courts to accept an agency interpretation of its own unclear regulation. unlike Chevron deference, if you recall, which applies to agency interpretations of unclear statutes. But the Kaiser ruling placed 4 limitations on the application of our deference. First, our deference only applies when a regulation is truly ambiguous. Second, the agency's interpretation of a regulation must be an authoritative or official position of the agency. Third, our deference is only appropriate for regulatory matters that fall within an agency's expertise. And finally, the agency's interpretation must be a fair and considered judgment that does not create unfair surprise for those subject to the regulation. So the Supreme Court in Kaiser unanimously vacated and remanded the judgment of the Federal Circuit Court of Appeals, which had failed to consider whether the regulation from the Department of Veterans Affairs at issue in the case had more than one reasonable meaning. The court instructed the Federal Circuit to reconsider its application of our deference in the case.
So since this was a 9-0 decision, does that mean that all of the justices agreed on these new our deference limitations?
Well, yes and no. So it was a unanimous decision, but there were 3 separate concurring opinions authored by Justices Roberts, Gorsuch, and Kavanaugh, and joined in part by Justices Thomas and Alito. Some of the concurring justices argued that the court should have eliminated our deference altogether instead of just leaving a weakened doctrine in its place. And they also emphasized that the court's support for our deference should not translate to support for Chevron deference.
Okay, so yet another case where we still don't have a definitive, swing one way or the other in terms of this principle. It's fascinating how these are all shaking out. Now let's look at the next deference-related case, which was PDR Network LLC v. Carlton and Harris Chiropractic Incorporated. What was at stake here?
PDR Network questioned whether a fax that was sent from PDR Network LLC to Carlton and Harris Chiropractic that offered them a free copy of the physician's desk reference was considered to be an unsolicited advertisement in violation of the Telephone Act. So the district court dismissed the case because they didn't consider the fax to be an unsolicited advertisement, but the Fourth Circuit Court of Appeals disagreed, and they argued that the Administrative Orders Review Act, which is also known as the Hobbs Act, requires district courts to automatically defer to final orders of the Federal Communication Commission, the FCC. So what's interesting here is that the FCC had issued a final order back in 2006 that interpreted unsolicited advertisements under the Telephone Act to include faxes like the one sent by PDR Network. And that's where deference comes into play here.
So if the district court was required to defer to the interpretation of an unsolicited advertisement in the FCC's final order, does that mean that Chevron deference or our deference was at play here?
So neither, actually. The deference in this case came from something else entirely. So an exclusive review provision of the Hobbs Act states that only the courts of appeals have jurisdiction to rule on the validity of FCC final orders. The Fourth Circuit interpreted this provision to mean that the district court was required to defer to the FCC's final order.
Okay, so then what did the Supreme Court have to say?
Well, the Supreme Court's decision here was really interesting. So the court remanded the case to the Fourth Circuit and asked them to answer some preliminary questions. First, the court asked if the FCC's final order was considered to be a legislative rule or an interpretive rule. Legislative rules make substantive policy changes, and they have the force and effect of law. Interpretive rules, on the other hand, include agency guidance, and they're meant to advise the public of an agency's statutory interpretation. So the justices argued that if the final order was actually an interpretive rule, then the district court wouldn't have been required to defer to the agency's interpretation.
All right, I think I got it. So then what else did the court question?
Well, the court also asked whether PDR Network had adequate opportunity to seek judicial review of the final order. Under the Hobbs Act, challenges to FCC orders must be brought in a court of appeals within 60 days of the issuance of the order. But the Administrative Procedure Act allows for judicial review of agency actions unless there's already been a quote-unquote prior, adequate, and exclusive opportunity for judicial review provided by law. So the judicial review provision under the Hobbs Act was prior and exclusive, but at least some of the justices weren't convinced that it was adequate.
Wow. Okay, so that's really interesting. So then, which justices indicated that it might not have been adequate?
Justice Thomas wrote a concurring opinion, joined by Justice Gorsuch, arguing that the Hobbs Act might be unconstitutional if it prevents district courts from independently interpreting the text of the Telephone Act. He also claimed that the case shows why the court should reconsider precedents like Chevron deference. Justice Kavanaugh wrote a separate concurring opinion, joined by Justices Thomas, Alito, and Gorsuch, arguing that the Hobbs Act doesn't prevent judicial review in private enforcement actions, which was the type of action in this case. So it's going to be really interesting to see how the Fourth Circuit responds to the Supreme Court's questions.
Yes, that'll definitely be something to look out for. All right, so let's switch gears now and move on to Gundy v. United States, which is a case that concerned the non-delegation doctrine. Can you tell us a little bit, Caitlin, about the non-delegation doctrine and how it related to this case?
Certainly. So the non-delegation doctrine is an administrative law principle holding that legislative bodies can't delegate their legislative powers to executive agencies or private entities. In other words, lawmakers can't allow others to make laws. But Congress often passes broad statutes that grant agencies the authority to fill in the details, so to speak, by issuing regulations. Some administrative law scholars have argued that these delegations of authority to federal agencies violate the non-delegation doctrine. So in the Gundy case challenged a delegation of authority to the Attorney General under the Sex Offender Registration and Notification Act, or SORNA, that allowed the Attorney General to decide how to apply the law to pre-existing cases. A number of journalists and analysts speculated that Gundy could be the first case to invalidate a statute on non-delegation doctrine grounds since the Supreme Court's 1935 decisions in ALA Schechter Poultry Corporation v. United States and Panama Refining Company v. Ryan.
All right, so those are like 80 some years ago.
Right.
Were the predictions correct?
No, but it's still interesting decision because several signs emerged that a potential majority bloc exists among the justices to invalidate statutes on non-delegation grounds in the future. The court ultimately ruled 5-3 to uphold the delegation of power to the Attorney General in SORNA, and in the opinion, Justice Kagan wrote that the delegation was constitutional because Congress set out an intelligible principle for the Attorney General to follow while executing the law. But Justice Kavanaugh had not yet joined the court and didn't cast a vote. Justice Alito issued a concurring opinion signaling that he would be willing to reconsider the non-delegation doctrine in future cases, and Justices Roberts, Thomas, and Gorsuch dissented.
So even though Gundy didn't become the third case ever to overturn a statute under the non-delegation doctrine, it could signal a turning point for future non-delegation challenges.
Exactly.
Well, that's definitely something to keep in mind for the upcoming terms. All right, so far we've looked at cases concerning deference and the non-delegation doctrine, but the next case we're going to review has to do with agency rulemaking. Is that right?
Yes.
Okay, great. Let's take a look at Azar versus Allina Health Services. How did this case relate to agency rulemaking?
Well, if you recall our discussion of the PDR network case, there's sometimes confusion about what qualifies as a legislative or substantive rule versus an interpretive rule. Analysts had anticipated that the Supreme Court in Azar would finally make a firm distinction between substantive and interpretive rules.
All right, so why is that such an important distinction for them to make?
Well, it's important because substantive rules must follow notice and comment rulemaking procedures, which means that members of the public have notice of the proposed rule, as well as an opportunity to provide feedback to the agency. Interpretive rules, on the other hand, don't need to follow the notice and comment process because they don't make binding changes to agency policies. Interpretive rules aim to clarify how agencies administer programs and regulations.
I see. So what specifically was the rule at issue in Azar?
Well, in the Azar case, several hospitals joined together to object to the way that the U.S. Department of Health and Human Services, or HHS, calculated certain Medicare reimbursement rates for the 2012 fiscal year. The hospitals argued that the Medicare Act required HHS to follow notice and comment rulemaking in order to make changes to reimbursement formulas.
So then what did the Supreme Court decide?
Well, the court declined to rule on a general distinction between substantive and interpretive rules, as many analysts had hoped, but it did provide clarity in the context of rules issued under the Medicare Act. So the court held that the text of the Medicare Act requires both interpretive rules and substantive rules to follow notice and comment rulemaking.
So even though the court didn't issue an across-the-board ruling on substantive versus interpretive rules, it did clarify the distinction in this narrow context.
Yes, that's right.
Fascinating. All right, so that brings us to our final case today, one that I imagine some folks have already heard about because it was talked about quite a bit, and that's Department of Commerce v. New York. What was the issue before the court in this case?
Well, this case challenged the addition of a citizenship question on the 2020 census. Commerce Secretary Wilbur Ross had said that he approved the addition of the question in March 2018 in order to improve enforcement of the Voting Rights Act, but it was blocked by 3 district courts.
And why did the district courts block that question?
Well, the district courts found that the question violated the Constitution's enumeration clause as well as provisions of the Census Act. And they also held that Trump administration officials had failed to follow proper administrative procedure when they approved the addition of the question. The government appealed the district court rulings directly to the Supreme Court in the hopes that a final decision could be reached before the census had to be printed.
Got it. And then what did the Supreme Court decide?
Well, this was another really interesting decision. So first, the justices ruled that the Trump administration's decision to add the citizenship question to the census was lawful, meaning that it didn't violate the enumeration clause or the Census Act. But what's most interesting here is that the court ruled that Secretary Ross's rationale for adding the question, which as you recall was to improve enforcement of the Voting Rights Act, was inconsistent with the administrative record. In other words, the administrative record in the case showed that Ross had an unexplained desire to add the question to the census and that enforcement of the Voting Rights Act was a means to an end rather than the primary motivation behind the decision.
So what was the end result for the citizenship question?
Well, in the end, the court remanded the case to the agency for further review. The Trump administration ultimately decided to seek citizenship data through existing federal agency records, and the question won't be on the 2020 census.
Right. Okay. And then that was also driven in part by the fact that there's a deadline coming up to prepare the forms and send them out to the printers for use for that census. I see. Okay, so is there a broader takeaway about this case for the administrative state?
Definitely. So judicial review is normally restricted to the administrative record in a case, but the court invoked an exception here. And the court cited precedent from a 1971 case, Citizens to Preserve Overton Park v. Volpe, to make an exception for evaluating agency decisions beyond the scope of the administrative record.
Wow. Okay. So what does that mean then for future cases?
Well, time will tell, but the dissenting justices expressed concern that the exception would open a whole new legal avenue for challengers to contest administrative actions based solely on alleged pretextual reasoning by agency decision makers outside of the administrative record.
That will definitely be something else to watch for in future cases, as we've talked about with some of the other ones that we've discussed. This has been a really interesting look at these administrative state principles and how these cases will shape them in the months and the years ahead. Thank you for giving us this rundown today, Caitlin.
Yeah, thanks for having me.
All right, I hope you enjoyed this look at the Supreme Court's most recent term, and in particular, this insight into some really important concepts. If you want to learn more about them, you can start with our portal page on the administrative state. Just go to ballotpedia.org and type in administrative state, and that will take you to it. Also, we have learning journeys, which you may have read about in the brew. We currently have ones on the Non Delegation Doctrine, judicial review, and Chevron deference, which is among the topics that we talked about today. If you haven't taken those yet, they're like a mini course you can take through email from us that includes information, examples, and exercises. I highly recommend those. And switching gears a little bit to elections, we're coming up on some really interesting elections in August. including the Mississippi gubernatorial primaries and municipal elections in Nashville and Seattle. So please continue to visit ballotpedia.org for updates on all the news about politics and elections. We invite you to keep in the know with all of our email newsletters, including the Daily Brew, which comes out every weekday, and our weekly newsletter, The Tab. So again, thanks for joining us. Thanks, Joel and Caitlin, and thanks everyone for watching.